If you've been arrested by the state of Delaware and you're facing criminal charges, you need an experienced trial attorney to represent you in unfamiliar territory. You're on the state of Delaware's turf. This is not a luxury. This is a necessity. I have tried 135 Superior Court jury trials throughout my career, including as a defense attorney and as a state prosecutor. I have tried numerous other hearings and trials in various courts, family court, court of common pleas, justice of the peace court. It is important not only as to what the charge is that you are accused of committing, but it is also important to consider, in the event that that matter goes to trial, what type of defense will be presented, how would it be presented, how would it be packaged, how would it be painted to the jury, because ultimately the jury is the person who will be deciding your fate. 12 individual jurors selected off of the street to sit in judgment of allegations the state of Delaware will be making against you. You need to consider, in deciding upon who will represent you, who will be your mouthpiece, who that will be, and how it would be presented to those citizens in the event this case ultimately is tried by the state of Delaware. After an initial arrest, your case will be sent to the court formally by the state of Delaware. If it is a misdemeanor offense, typically that is done by information. If it is a felony offense, typically that is done by the use of an indictment by the grand jury. The grand jury simply finds whether or not probable cause exists. If you are arrested, in all likelihood, and it is a felony, in all likelihood, you will be indicted at some point by the grand jury. That brings the case to the court. And after that, there will be certain steps which will take place in the prosecution. There will be arraignment. There will be case review. There will be a second case review called final case review. And finally, there will be a trial. In most cases, the state of Delaware looks at the case and tenders an offer to the accused of a plea. That plea can be accepted or rejected. It can be rejected and a counteroffer can be made. The important thing to consider is the decision as to whether or not to accept an offer by the state to a reduced charge or to the charge is your decision, with input by your represented counsel. In the event that it is decided by you not to accept any plea, then the case is set for trial, at which point the state presents its evidence, and you have a right to present evidence if you wish. You also have a right to not to present evidence. The most important factor is that your representative at trial must be familiar with how a trial is conducted and what to do, not only substantively but procedurally in the course of that trial. What motions to make, what objections to make, what objections not to make, how to read the jury, what is the best effective technique for your particular case in that particular instance with that particular judge, with that prosecutor. If you are arrested and charged, call me, John Garey, in Dover, Delaware at 302-744-9290.
You can also visit our website at www.johnrgarey.com for more information and to arrange your free consultation.